Oh, I'm not sure. Maybe
Meadow Creek.
Meadow Creek. Yeah. But I'm not sure. I think we still have to get we just still, I think we still have to do it on build.
Those are some poor houses on the terrace and up there.
Well, a lot of them are up there.
There are really little houses.
Yeah, well, I did that. Not half of them.
Down a little bit more.
Association, Indian Creek Watershed Association, Ashby, Berkeley, Todd and Susan Bolden, petitioners, Austin Caperton, Secretary Deputy, West Virginia DEP, Mountain Valley Pipeline LLC, West Virginia Environmental Quality Board, Civil Action 18AA1. Could we just note for the record who's representing who, starting with
David Barney for the petitioners.
Kevin Thompson for the petitioners.
and Kevin, Austin Caperton?
Bob McCluskey and Jennifer Hughes for MVU.
Okay. Are there any preliminary matters we need to talk about?
None from the petitioners, Your Honor.
All right. Turn it over to the petitioner.
Thank you, Your Honor. We're here on our appeal of the EQB's decision on the natural stream protection permit. The NSP seeks to regulate the diversion, impoundment, and flooding of the Greenbrier River and 3 other very important rivers that the legislature has designated to be controlled and protected by this very statute. Right off the bat, this is a dry cut process that involves a coffer dam. So the EQB's findings of fact and conclusions of law and the DEP's position and the MVP's position that the NSP does not apply here are wrong, because clearly when you cut off half of the stream, it is in fact a diversion, impounding half of the stream's water behind the coffer dam in which the dry cut operations are going to be conducted. Now, the permit, however, could allow such a diversion or impoundment, much like when an industrial facility goes in. The clean water standards may say that the company cannot discharge in excess of a certain amount of pollutant, but there can be a permit entered which would allow such a variance. Here, the permit allows diversion, but only if there's a temporary and non-permanent impact. It's not a strict liability standard, which is important, because that brings in the question of, well, if the statute says you can't impound and you can't divert, then under what circumstance could you divert or impound? It stands to reason that what the standard is and whether or not the permit is to be granted is one of reasonableness. And reasonableness here goes to impact. Impact of the impoundment or the diversion is the effect on the natural stream condition. I point this out because throughout the EQB hearing and in the briefing by the respondents, there's been an attack on Dr. Dodds's emphasis on water quality, the stream bed and its ability to support aquatic and benthic life, and then the role that would play in the food chain, because the Greenbrier River is one of the protected rivers, It's a river which is known for its aquatic life and allows for economic development, fishermen, kayakers, things like that, to participate. So the impact of the diversion and the impact of the impoundment goes beyond the mere physics of whether or not the water is moving in a certain way to a certain place, but rather the effect upon the natural stream conditions. And in fact, at page 15 of the certified record, the last section of the application is stream restoration. And MVP itself says that stream impacts within the pipelines will limit disturbance, will be temporary, and will only occur during the pipeline construction activities. It says the temporary water body crossings will not result in a long-term impact to water quality, physical habitat, or aquatic species within the Greenbrier River crossing project. The fact that their application has a required section, stream restoration, and the stream restoration response that the MVP pipeline put forth implicated water quality and turbidity, physical habitat, and aquatic species makes very relevant the testimony that the EQB, DEP, found irrelevant from Dr. Dodds. It is very relevant what the impact on the stream conditions, the aquatic life, and the species are. And then we go forward to section 6 of the Dodds report, which is found at page 298 of the certified record. And in section 6 of the Dodd report, page 5 of her report, and as I pointed out, page 298 of the certified record, Dr. Dodds writes, the MPV provides an assessment that was made to determine the monthly sediment load increase due to construction. Relying upon the calculations set forth by the MVP, Dr. Dodds points out then that for the Greenbrier River, the monthly sediment loads are estimated to increase from 19 to 52%, which will permanently degrade aquatic habitats. Furthermore, in testimony, Dr. Dodds relied upon government documents measuring the cubic feet per second flow rate of the Greenbrier River. And she pointed out that during the floods in 2016, the CFS was in excess of 10,000 cubic feet per second. In the case of a worst case scenario, which is what permitting and environmental protection always has to take into effect, then one can easily infer that the 19 to 52% sediment loads would be dramatically increased in the event of a large flood. Dr. Dodds goes on to point out that the cumulative damage to aquatic habitats through time will not disappear, but will rather cause the death of aquatic organisms and will reduce the water quality. So while the EQB, the DEP, and the MVP want to focus on the temporary nature of the construction activity, Dr. Dodds pointed out that in fact those temporary increases in turbidity will cause a permanent change in the condition of the stream bed. And by filling in voids where small aquatic life that forms the bottom of the food chain for the predatory species that drives the tourism economy here, that sediment, which is increased in the flow, is going to drop onto the stream bed and create a permanent problem for the aquatic life. And every aquatic animal that dies early before its life cycle is completed will have a continuing effect on the benthic health and the aquatic life in the area. Now, Dr. Dodds testified on the basis of her experience and her education. The respondents have pointed out that she's merely a geologist. The EQB pointed out that she testified that she was not a biologist, but she is in fact a marine geologist. She has a PhD in marine geology. From 1985 to 2000, she worked for the Virginia Department of Environmental Quality in just this area of expertise. And the fact that the turbidity in the water is going to settle and change the nature of the stream bed, the natural stream condition, is completely within the wheelhouse of someone who has a PhD in marine geology. And furthermore, I'd like to point out that the ruling by the EQB was made under Rule 50, not pursuant to Rule 52. The EQB has the advantage of the use of someone from the Attorney General's office that advises them on issues like this, on procedural and legal matters. A choice was made for them to issue their decision under Rule 50. Rule 50, as we pointed out in our briefing, is not amenable in an administrative law setting. That's something that is reserved for a jury setting, not an administrative law setting. So for that reason, we would ask, besides all of the persuasive scientific evidence that we've presented and Dr. Dodds has presented, we would ask it be overturned. Furthermore, we'd like to point out to the court that the United States Fourth Circuit Court of Appeal, since the stay was entered by this court, entered a decision in the Sierra Club, West Virginia Rivers Coalition, Indian Creek Watershed, Appalachian Voices, and Chesapeake Climate Action Network versus the Corps of Engineers and the Mountain Valley Pipeline as an intervener. That decision, I think, pretty well takes care of any federal preemption issues that may be raised, any issues that could be raised concerning the National Gas Act. And then on the factual point of the opinion, it brings into focus exactly what we're talking about here.
Can I stop you a minute?
Yes.
Did they actually issue an opinion, or is it just this order that was attached to your reply?
It's the per curiam order.
Okay, I thought that they were supposed to issue a more.
Your Honor, Bob McCluskey, the per curiam order does say opinion to follow, and it has not yet followed.
Yeah, well, that's why I was getting at. This is just what was filed. I mean, there's no further opinion.
Correct,
Okay, I
correct.
just wanted some clarification.
Right. We're expecting an opinion to come down, but none has been pointed out. And the Fourth Circuit in the per curiam order said, among other arguments, petitioners assert that in issuing its verification, the court improperly imposed one condition, requiring the use of a dry cut method for constructing the 4 river crossings in lieu of a special condition imposed by the state of West Virginia that individual stream crossings must be completed in a continuous progressive manner within 72 hours. Construction of each of the 4 river crossings using the dry cut method is expected to take 4 to 6 weeks to complete. And I think 4 to 6 week completion is consistent with the application thus far. So it's a dry cut, and the Fourth Circuit found that the federal law doesn't preempt and doesn't occupy the field that is presented here. And instead, they said that West Virginia's 72-hour temporary restriction was the controlling standard. So because the NSP concerns impoundments and diversions, and the fact that a cofferdam is in fact an impoundment and diversion, there is really no question as to whether or not the NSP permit is required. Regardless of whether one finds persuasive the DEP's position that it may or may not be required, they did go ahead and file it. It's not strict liability, and therefore it impacts reasonableness. By impacting and drawing into the court's consideration reasonableness and impact, then issues like aquatic life, aquatic species, and the condition of the stream being conducive to life for those aquatic species becomes extremely relevant, and therefore we think for that reason alone, this should be sent back down to the EQB for further testimony and consideration of those items that were put forth. And then again, as I said before, we have the Rule 50 issue, and I think that the court can take persuasive guidance from the Fourth Circuit. Thank you.
Okay. Mr. Husky, you want to start?
I do. I'm going to step back a little bit. As the court knows, Mount Valley Pipeline is proposed to run about 303 miles from Drexel County, West Virginia, to Pennsylvania County, Virginia, and allow transport of gas produced in West Virginia to regional markets. I know it's not popular with some in this courtroom here today, but it will benefit many in the northern part of the state. Along the way, it will cross streams and rivers, and in West Virginia, there are 4 major river crossings, with the Greenbrier River being one of the 4. And that's the crossing near Pence Springs. As Mr. Thompson said, that proposed crossing will use portable cofferdams. There have been pictures presented to the court, and I don't know if the court has had an opportunity to see them. We have them with us if the court would like to see them.
I think I looked at them last time.
Okay.
We talked about it.
So in our brief, there's one, I'm just going to hold it up, Your Honor. And Interveners Exhibit 7 is another example of one.
And I think that's a picture we saw last time.
We did, it's in the brief. And the portable cofferdams will allow excavation in an area that's isolated from water while the excavation is undergoing. The trench will be cut, a pipe will be placed into the trench will be backfilled with rock, and then the ported dam will be flipped to the other side of the river, so it'll only cover half the river while under construction, and the process repeated, so that excavation is not occurring in flowing water. And that's important because Mr. Thompson just made a statement. He's kind of tried to change gears here a little bit. The report he mentioned from Dr. Dodds was not, I believe, introduced as an exhibit before the Environmental Quality Board. It is a report that was filed as a comment with FERC and the West Virginia DEP about an earlier proposal by MVP that is not the proposal that was approved by FERC, or the Corps of Engineers, or DEP. The original proposal evaluated by FERC in something called the draft environmental impact statement called for an open wet cut. Very different than what's before the EQB. A wet cut is just what it sounds like. It is a cut taken without any cofferdam protection of the excavation area from any water that may be flowing. Typically done during low flow or no flow times of the year where that's available. But that was the original proposal, and that was the proposal that Dr. Dodds was commenting on that resulted in increase in turbidity. The cofferdam was a reaction to that. The cofferdam was approved by FERC in response to comments that a wet cut would cause that 19 to 52% increase in turbidity. So those statements in that report have nothing to do with this case. Just want to make that very clear at the outset. So the Natural Stream Preservation Act permit issue here is a very small component of a much larger regulatory process. The primary environmental review and the primary permit issued for any natural gas interstate pipeline under the Natural Gas Act is issued by the Federal Energy Regulatory Commission, FERC. They issue a certificate. As part of that process, they conduct first a draft environmental impact statement and then a final environmental impact statement in consultation with other federal agencies and with the state agencies in West Virginia and Virginia. They do a comprehensive environmental review. As part of that, they finally issued a FERC certificate. They actually mandated water crossing methods for the 4 major river crossings in West Virginia, including the Greenbrier. It requires the use of these portable cofferdams. And we have copies of that. We've only cited to the FERC certificate and the EIS in our briefs, Judge, just because they're so long, but we have copies of the FERC crossing provisions should the court want to see them. There is, in addition, a construction stormwater permit issued by the West Virginia DEP. That was really the permit the appellants wanted to appeal but didn't. I don't know why.
Yeah, run that by me again, what?
There's a construction stormwater permit issued by the West Virginia DEP under the provisions of the West Virginia Water Pollution Control Act. That permit is designed to regulate erosion and sediment from the pipeline construction, largely in upland areas. So it largely does not regulate the crossing itself, it regulates the areas adjacent to the crossing. That permit imposes controls on what can be done and what has to be done in the field in order to reduce the sedimentation leaving the site. It protects water quality and water quality standards. And the standards that Mr. Thompson talked about are standards that are issued pursuant to the Water Pollution Control Act. That is the statutory authorization for that construction permit. Excuse me. The Natural Streams Preservation Act does not regulate water quality. There is in addition a Corps of Engineer permit issued under Section 404 of the Clean Water Act. That permit is issued for the discharges of dredged or fill material into waters of the United States. It governs every aspect of water dams at the crossing. And we provided in one of our briefs, I think, an exhibit to the Corps' verification that that permit is available to MVP.
But wasn't that the whole effect of the Fourth Circuit ruling to invalidate that
Yes.
permit?
So that permit, in addition to being issued under Section 404 of the Clean Water Act, requires something called a 401, it's just a section of the Clean Water Act, certification from the state that the project will meet state water quality standards, the same standards Mr. Thompson's talked about. The state certification has a provision in it that said that crossing should be effected within 72 hours. We don't know yet, as Your Honor's pointed out, but we suspect that will be the basis of the Fourth Circuit's opinion when it comes out. But as a result, Mr. Thompson is correct. As we stand here today, the 404 permit is not available for use to cross the Greenbrier River. So I want to make that clear. And as a result of that, without that permit, the Natural Stream Preservation Act permit cannot independently authorize the crossing either. So as we stand here today, MVP is unable to cross the Greenbrier River until it solves the 404 permit problem with the court. So we do not need a ruling from the court today on the Natural Stream Preservation Act permit. We would like it in a reasonable time frame so that if it is impaired and we resolve the 404 issues with the court, it's available. So we do not need a resolution today as we stand here.
It seems like to me that a lot of it is, pretty much all of it is totally dependent on what happens in another form, what the Corps does, what the Fourth Circuit does, what FERC does. This is probably all going to change, or may change. I don't know.
Your Honor, I'm certainly not the guy, I'm not the engineer, I can't tell you the answer to that. It is our goal to reinvigorate the 404 permit, revise that if we have to, once we understand exactly what the Fourth Circuit is going to do, and then use that permit and the Natural Stream Preservation Act permit. But I can't tell you that things won't change. I mean, they've changed a lot. They change these projects from week to week.
So you want me just to hold up until we hear from the Fourth Circuit?
No, I don't think so, Your Honor. I think, all I'm saying is the court need not rule from the bench today. We, to the extent can resolve our differences on the 404 permit, the goal would be then to use this, but it's not going to happen in the next several weeks. Or
You know, to tell you the truth, I feel kind of like a man that's blindfolded trying to throw darts, play darts while you're blindfolded. Not knowing what the Fourth Circuit's going to say in their opinion, not knowing what the Corps is going to ultimately decide is appropriate, not knowing what the West Virginia DEP decides is appropriate.
I understand, Your Honor. I'd like to sit down if you're going to throw darts, though.
All right, thank you, thank you. Are you finished?
No, I'd like to go on.
Oh, okay. No, I don't want to be darts. I mean, you understand how I feel, though. I mean,
I do.
there's a lot of other things that have a bearing on the outcome here. I mean, the whole project may be changed. I mean, you know, your client could decide to put the pipeline over the river or bore under the river or do something that doesn't impact the river or require water, doesn't require this kind of a permit.
That's true, that's
I mean, it could be that this just goes away, this whole problem.
it could be, but as we stand here today, we don't know that. And as I said, the intention is to reinvigorate the 404 program if we can, and then use the Natural Stream Preservation Act permit. Now, as I said before, we're in a high flow time of the year where the cofferdams are not going to be used during the high flow time of the year, so we have some time. We just don't have an infinite amount of time. So we have the construction stormwater permit that regulates water quality impacts of all the upland activities. We have the FERC certificate, which also regulates environmental impacts and requires the cofferdams. And then we have the 404 permit from the Corps. And then finally, we have the Natural Stream Preservation Act permit. Mr. Thompson's right, that statute is specialized. It regulates, I think, 5 rivers and streams in the state of West Virginia, the lower Greenbrier being one of them, and Anthony Creek and Greenbrier being another of the 5. And it prohibits modifications of protected streams without a permit. And then the permit criteria set forth in section 7 of the statute are 3. There are 3 findings required from the DEP. And that's under section 7A of the Act. First, there has to be a finding that proposed work will not materially alter or affect the free-flowing characteristics of a substantial part of a protected stream. The statute defines free-flowing characteristics as flowing without impoundment, diversion, or flooding. So using those definitions, the first criterion of the statute is that a finding is necessary that the activity will not materially impound, divert, or flood a substantial part of a protected stream. That's the first criterion. The second is that the work is necessary to prevent an undue hardship to the permit applicant. And the third is simply that the work meets with the approval of DEP. DEP determined that the activities here met all of those criteria. We had a hearing before, an evidentiary hearing before the Environmental Quality Board. That board statutorily can consist of up to 5 people. 3 members heard it, 3 is a quorum. The members who heard it were a biology professor at Marshall University, a geology professor at Shepherd College, and retired head of the forestry division of West Virginia. They ruled unanimously in favor of DEP and MVP. In this appeal, the appellants, they didn't mention in the oral argument, but they have 3 different things that they have brought before the court, at least in their briefs, and I intend to go forward unless the court doesn't want to hear it. I'm going to address all 3 of them.
I mean, I'm here to hear whatever you want to say.
First, they argue that the EQB wrongly affirmed a finding from DEP that MVP would suffer undue hardship in the absence of the permit. That's their first argument. Second, they argue that the EQB wrongly determined that the water quality issues were beyond the scope of the statute, and also that the board wrongly found that they failed to prove a prima facie case of violation of water quality standards. And then third, they claim that the board wrongly granted judgment on claims that MVP would impound, divert, or flood substantial parts of the Greenbrier River. And there, at least the evidence and the arguments before the board relied on Dr. Pamela Dodds and were broken into kind of 2 parts. First part was a claim that upland activities, those things outside of the river itself that are regulated by the construction stormwater permit, would somehow have those prohibited impacts. That is, they would impound, divert, or flood the Greenbrier River. And secondly, she claimed that the trench itself in which the pipe would be laid, the material backfilled into that trench could wash out during high flow events and also have prohibited effects on downstream waters. So our view is that each of these can be addressed as a matter of law without resort to the record below. That is, there is an easy button here for the court, and we urge the court to use it. First, on the undue hardship issue, the EQB did not find that DEP made a finding or affirmed a finding that the company would incur undue hardship absent permit. Instead, what the EQB found was that the issue had never been raised by the appellants. They don't address on their briefs. They do not point out how they did raise the undue hardship issue in their initial appeal to the board. The board ruled they didn't raise it. They tried to get into it in the hearing, and there was a ruling, evidentiary ruling between pages 43 and 58, where EQB sustained an objection. The issue simply was never raised before the board. There's no evidence to support it. And as a result of the failure to raise it before the board, this court, essentially sitting as an appellate court in this case, cannot now review that issue. So that ought to be the end of the undue hardship. The water quality standards issue was raised before the EQB. In fact, it was the only issue raised before the EQB. And the claim there was that MVP would generate sediment in concentrations that violate the state water quality standards in some fashion. But as we pointed out, water quality standards are already protected by the FERC certificate, the permit issued under the Water Pollution Control Act to control construction stormwater, and by the Corps of Engineers 404 permit for the crossing. And any challenge to whether water quality standards will be met is an issue that under the Natural Gas Act has to be filed in the Circuit Court of Appeals. Original jurisdiction lies for any challenge to federal statute. In West Virginia, the water quality standards are part of a federal program. State issues them, they have to be approved by EPA. The EQB agreed that the water quality issues were outside the scope of the Natural Stream Preservation Act. It ruled that the Natural Stream Preservation Act is concerned only with whether activities would impound, divert, or flood the river. Appellants seem to agree, notwithstanding Mr. Thompson's arguments here today. I'm going to read from his own amended appeal. It says, this is paragraph 32 of the amended appeal filed by the appellants. Based on the plain language of the Act, the proper issue for the EQB's consideration was whether MVP's proposed activities will impound, divert, or flood a substantial part of the Greenbrier River. We agree. That's the sole issue under the statute. It was before the board, it was before this court. So the board got it right on water quality standards as well. They are protected by other statutes. They are issued under the Water Pollution Control Act, pursuant to which another permit was issued. So taking them at their word in paragraph 32 that this case is about impoundments, diversions, and flooding, let's look also at their original appeal. Your Honor, may Ms. Hughes approach the bench with a copy of the original appeal? Your Honor, this is the original appeal filed before the Environmental Quality Board by the appellants. And I direct the court and the other parties to pages 5 through 7 or 8, where they list 15 specific objections. And they all, and I've highlighted parts of some of these, but each and every one of these relates to water quality and water quality standards and turbidity. There is not a single mention in any of these paragraphs of impoundments, diversions, or flooding, or interference with the free-flowing characteristics of the river. This entire appeal was limited to water quality, which is why I said at the outset they really intended to challenge a different permit. So as a matter of law, these issues were never before the board properly and are therefore not before this court. I believe the same thing is said in the appellant's brief at 925 on page 4. They condensed The arguments they've raised in the 5 specific objections, again, construction of the pipeline would lead to increased sedimentation and turbidity. Paragraph 2, increased turbidity and chemical contamination, negatively impact water quality, no provisions to protect the Big Bend Public Service District intake. The Greenbrier River would be contaminated because water withdrawn for hydrostatic testing would be treated with biocide. Again, nothing dealing with impoundments, diversions, or flooding. So as a matter of law, the 3 issues they've raised here today, only one of them was raised before the board. That's the water quality standards issue. The board appropriately ruled that water quality standards are governed by other statutes or outside the scope of the statute. The other 2 issues were simply never raised, that is, impoundments, diversions, and undue hardship. But if the court nonetheless wants to, I'm prepared to address the record evidence on each of these issues as well. And I hate to burden the court with it, but I intend to go through it since it's my only shot. But as a matter of law, we believe all 3 issues can be resolved without resort to the record. So on the undue hardship issue, the appellants have claimed that they put on sufficient unrebutted evidence that DEP wrongly determined MVP would suffer undue hardship without the permit, at least sufficient to avoid judgment. Now, in their brief of 925, on page 7, they cite the transcript for that proposition. They cite pages 78 through 81. I went and looked at that citation. That's the testimony of Ms. Laura Cooper, who was overseeing the Natural Stream Preservation Act permit program. And that testimony, she simply summarizes the fact that there were no practicable alternatives to this river crossing. That testimony supports DEP's decision and MVP. It does not support a claim that DEP erred in any way. On the water quality standards issue, they again claim that they offered sufficient unrebutted evidence that potential increases in sediment levels would violate state water quality standards. But they provide no citation in the transcript for that proposition on page 11 and 12 of their brief. And the EQB found otherwise. The EQB found they offered no evidence on that. They offered no evidence that potential increases will violate any of the state water quality standards. In their briefs, the appellants just make conclusory statements, but water quality standards are issued by the state under the State Water Pollution Control Act. There is a rule that lays them all out. At West Virginia Code of State Regulations 47-2-1 through -9. And there are concentrations established for all kinds of pollutants. Turbidity is one of those. There's been no effort either in the record below or in the briefs to this court to identify what that standard is, describe it, describe how it can be measured, and there's no evidence anywhere in the record that the activities will cause a violation of a turbidity standard. None at all. The board further found, appropriately, and we've cited to the transcript on this, that while Dr. Dodds did say there would be sediment generated, she did nothing to try and quantify how much, what effects it would have, and where those effects would be. All of which, by Mr. Thompson's own admission, are important because the standard here, as he said, is not strict liability, it's whether there will be material impacts to impoundments, diversions, or flooding to a substantial part of the river. So even if this was an appropriate issue to be considered, she was unable to quantify that there would be substantial impacts. On the impoundment, diversion, and flooding issue, again, the appellants claim that they put on evidence sufficient to survive a judgment below. They cite, again, rely on Dr. Dodds on page 11 of their brief of September 25th. Dr. Dodd's testimony appears at pages 136 through 172, at least her direct examination by the appellants. I reviewed every page of that. Not once in her direct examination did she ask whether MVP would impound divert, or flood the Greenbrier River. Not one time. It wasn't part of their case because it was a water quality standard case. Later on, the appellant's brief on pages 6 and 7 cites two parts of the transcript for their claim that they offered unrebutted evidence that either the backfilled trench or the upland activities would cause impermissible issues. And those citations, I went and looked at those as well. Page 60 of the transcript they cite, that's DEP's Laura Cooper again. On page 60, Mr. Thompson asked her whether trenching and backfilling will change the nature of the stream bed and the way water flows. Again, this is something they cited. Ms. Cooper responded she did not believe it would materially alter the free-flowing characteristics of the river. Same thing, pages 77 and 78 are cited in their brief on page 6 and 7. Again, Ms. Cooper testified that the proposed project would not materially alter the free-flowing characteristics of the river. It's a temporary activity and water will still flow. Later, Ms. Cooper explained.
I'm sorry, can you repeat that last phrase?
Maybe.
After free-flowing characteristics of the river.
It's a temporary activity, water will still flow. Later, Ms. Cooper, cofferdams were an impoundment or diversion. The water will be restricted part of the river, but would not divert the flow outside of its normal channels. And that was DEP's construction of the statute. It's not been challenged here at all. That is restricting water to part of the river, but not diverting it out of its historic river channels, was not considered diversion by DEP. Dr. Dodds conceded that the cofferdams are not truly impoundments. They exclude water rather than impounding it. She also tried then to pivot and say that it's a diversion, but all she could say was when you constrict the flow of water, you increase the velocity or raise the height of the remaining flowing part of the river, but she was unable to quantify that at all. The board so noted. So, in sum, all three of these issues fail as a matter of law, but also all fail on the record. There's simply no record evidence to support the claims that have been advanced by the appellants. And the board so found, and the board correctly found. And the standard of review here, regardless of whether the board cited the right rule for, I'll use the term directed verdict, even though I know that's not the correct term anymore, but the standard of review here is governed by the West Virginia Administrative Procedure Act. So West Virginia Code 29A-5-4G5, I believe, provides that the standard here is one of clearly erroneous. That is, the court can disturb findings by the board only if it finds they were clearly erroneous based on the record. And there is, in our view, no way that can be done given the sparseness of the record and the issues the appellants advance. I can address the preemption if the court would like. I think it's written in the briefs. But our view is the Natural Gas Act preempts any construction of the Natural Stream Preservation Act permit that would interfere with the use of the FERC certificate and the stream crossing plans approved by FERC. So the Natural Stream Preservation Act is construed to prohibit or substantially limit those activities that it is preempted by the Natural Gas Act. The FERC certificate, the appellants have tried to circumvent that by saying the FERC certificate requires compliance with the Act. We pointed out that's taking some language out of context. The FERC certificate actually has a provision in it, in paragraph 309, I believe, that provides that no state or local law can be construed to interfere materially with the conditions of the FERC certificate, which have a crossing plan that allows these crossings. So that's our case, Your Honor. We believe that as a matter of law, all three of the claims they brought failed. The board got it right on the facts as well. The board heard their evidence. There's nothing there. And then to the extent there was anything there that was preempted, we believe that in light of the fact that merits are overwhelmingly in our favor, and the fact that the 404 permit is currently unusable, that the stay should be lifted as well.
Does the DEP wish to be heard?
No, DEP would join in.
Is there any response?
Yes.
Mr. McCluskey's question as to why we didn't oppose the construction stormwater permit. 404, 401, Clean Water Act, and the panoply of other statutes and regulations that might impact it. It's quite simple. First of all, there were other people who were fighting Clean Water Act, federal standards which are enforced through the primary jurisdiction of the DEP, and they were fighting those battles in other courts pursuant to the federal statutes. And in fact, they've been quite successful. We, on the other hand, chose a very special law in the state of West Virginia, the Natural Streams Preservation Act, which identifies this as a very special river, which is entitled to very special consideration and very special analysis. Analysis that goes beyond taking the temperature of the river, as it were, on a temporal basis to see what the concentration of turbidity or various constituents are at any given point in time. I'd like to point to page 107 of the first certificate, paragraph 309, that says, any state or local permits issued with respect to the jurisdictional facilities authorized herein must be consistent with the conditions of the certificate. We encourage cooperation between interstate pipelines and local authorities. This does not mean that state and local agencies, through application of state or local laws, may prohibit or unreasonably delay the construction or operations of facilities approved by the Commission. FERC said that, and the Fourth Circuit didn't agree. The Fourth Circuit said West Virginia has a special condition, a special condition that prevents anything in excess of 72 hours when you're disturbing the waterway with a crosscut, and that's why this is so very important. West Virginia has special conditions. Our rivers and our waters are a special resource that perhaps will give us special advantages in the years and decades to come, and one crossing that can harm the aquatic life is exactly why the legislature and the people of West Virginia have the Natural Streams Preservation Act. And then the issue then falls back to, what can this court do in the time that it's been given by the Fourth Circuit to ensure that proper analysis and proper credit is given to the natural stream conditions? Well, we would ask that this be remanded, and we're not arguing this on a Clean Water Act basis. The brief, the argument, both Dr. Dodds' initial report and her testimony all go to the effect that this impoundment and diversion is going to have on the natural stream conditions. And I'd like to point the court to page 6 of the certified record. That's the application. And I'll just pull it out and show it to the court. This is the application for the Natural Streams Preservation Act. And there's a form.
What page were you referring to?
I'm referring to page 6 of the certified record. There's a form, and it's like most of the environmental permits that are given. There's a form that lays out some simple standards, and then those answers are expanded upon in a more fulsome writing that I referred to earlier when I went to section 5, stream restoration, that's on page 15 of the certified record. But I'd like to direct the court to page 6 of the certified record, which is the form, and it says stream restoration plan. The third sentence of the MVP's answer is, natural stream channel design practices will be employed during restoration to ensure that the channel's proper hydrogeomorphic conditions and characteristics are restored. The testimony about the increased sediment load by the upland diversions, the testimony about how the permit's description of the fill is going to expose the top layer of the fill, which would be the top of the stream bed, to increase scouring, because you're going to have increased pressure, because you've now cut off half the water supply. You're going to have increased sediment coming downstream from upland, so the increased velocity because of the diversion going halfway across the river is going to increase that. And Dr. Dodds, a marine geologist who knows about how rocks and water work together, opined without any rebuttal, without any opposing testimony, that this increased scouring is going to send sediment and is going to basically rip off the top layer that MVP will put back over the cut for the pipeline. Why is this important? Well, as I said before, Dr. Dodds pointed out that there's going to be a cumulative impact. In air pollution cases, you take if someone's going to violate a standard, it's because at some certain point in the day, they put too much of a contaminant into the air at that particular moment. However, there's hundreds of cases for lead and arsenic exposure across the country where, although a plant hasn't exceeded any moment-to-moment air quality standard, the cumulative effect of the particulates falling out of the air is increased contamination that harms human health and the environment. That's what we're talking about here. It's irrelevant whether or not at any given moment there's going to be a violation of a water quality standard under the Clean Water Act for the purposes of this action. This action goes to, as is on page 6, the proper hydrogeomorphic characteristics of the stream. And that's what Dr. Dodds testified to. That's why the water quality issues are so important in this matter. What we would like the court to do is to send this back, to remand it to the EQB with specific instructions that they're finding that water quality, sedimentation, scouring of the stream bed are irrelevant, to undo that finding and to say, no, you must actually consider, as in page 6, the proper hydrogeomorphic characterizations. On page 16 of the certified record, temporary water crossings will not result in long-term impact of water quality, physical habitat, or aquatic species with the Greenbrier River. That's their words. That was one of the bases that they put forth to the DEP in support of their NSP permit. And just because the DEP said it below and the EQB agreed that water quality and water quality issues and scouring are not issues, the application itself belies that. And the Fourth Circuit opinion certainly gives this court the power to review these issues that are specific to West Virginia. And if we're going to hit the easy button, as Mr. McCluskey referred to, a really simple easy button is Rule 50 versus Rule 52. Rule 50 versus Rule 52 sends it back. So that would be an easy button, and as Mr. McCluskey in the court inquired during his argument regarding the timing of this now, there's ample time to send it back to the EQB. So the Division of Forestry retired head and the Division of Water Quality retired director. So these board members can be instructed to actually consider the issues that Ms. Dodds was raising. One final point, his initial point correctly identified the fact that Dr. Dodds' initial report was aimed at a different method, and that after that report that there was an adjustment in the construction techniques. That's true. However, at the hearing, she extended the same principles from her first report into the second report because the dry cut still creates issues that were pointed out by the Fourth Circuit. So with the luxury of the time afforded by what's gone on at the Fourth Circuit and the critical importance the legislature has placed on protecting this stream, combined with the application's reference to water quality, turbidity, and the hydrogeomorphic characteristics of the stream, we would ask that the court return this to the EQB for further proceedings and to take into account those issues that they decided were not an issue in this case.
All right, thank you, Mr. Thompson. Do you have anything further?
I do, Your Honor. First, let me say, as a matter of law, Mr. Thompson has looked at cited paragraph 187 of the FERC certificate for the proposition the Natural Gas Act does not preempt state action. That is flatly wrong. Paragraph 187 of the FERC certificate says, in addition to the measures we require here, the Army Corps, the Pennsylvania DEP, the West Virginia DEP, the Virginia Department of Environmental Quality have the opportunity to impose conditions to protect water quality pursuant to sections 401 and 404 of the Clean Water Act, a federal statute. The Natural Gas Act does not, I agree, preempt the application of either federal law or a state acting pursuant to federal law. It only preempts the applications of purely state statutes like the Natural Streams Preservation Act permit. The Fourth Circuit opinion and the state condition mentioned in there is a condition imposed by West Virginia DEP pursuant to Section 401 of the Federal Clean Water Act. That is not preempted. And that's why that case was in the Fourth Circuit, because the Natural Gas Act provides original and exclusive jurisdiction for challenges involving water quality standards to the Circuit Courts of Appeal. So the Fourth Circuit opinion does not provide any basis for concluding that the Natural Stream Preservation Act permit is not preempted, none at all. Secondly, Mr. Thompson said that the EQB erred when they said water quality standards were outside the scope of the statute. They didn't just do that, though. They didn't just say, we're not going to consider it. They listened, they let him put his evidence on, and they made a finding that the appellants offered no evidence that potential increases in sediment levels from either in-stream or upland construction will violate any of the state's water quality standards. That's finding 24 of the order. So they addressed this. They made findings. They didn't just rule that it's outside the scope of the statute. And he says Dr. Dodds said this, Dr. Dodds said that. He says Dr. Dodds imported this comment she made about the wet cut into the dry cut testimony before the hearing. It's not in the record, and they can't cite it. It's not there. I asked Mr. Thompson to show the transcript where she imported that testimony. It's not there. In fact, the board, if you look at the transcript, you'll find she conceded she didn't know how much of the river would be affected by any sedimentation that would be generated. And that's on page 214 of the transcript. On pages 202 and 209 through 208 through 209, she said she had no idea of the volume of the sediment that could wash out of that trench. She was unable to quantify anything. So there's nothing to send back here. The board probably found that even if these were issues were probably before it, they didn't produce any evidence.
I just addressed some comments about paragraph 187, because I decided actually paragraph 309 for the proposition that that the Fourth Circuit considered that and then made a ruling that differed with the FERC certificate. His point about 187 ignores the last two sentences of that paragraph. It talks about in the first paragraph that the DEP, PODEP, and VAWDEC, Pennsylvania Department of Environmental Protection and Virginia Department of Environmental Quality have opportunities to impose conditions to protect water quality pursuant to sections 401 and 404. He's right about that. But then that paragraph goes on to say, the applicants must obtain all necessary federal and state permits and authorizations, including, which means if it includes the water quality provisions, then there must be something else, including water quality certifications prior to receiving the commission authorization. The final sentence then says, we expect strict compliance by the applicants with any federal and state mandated conditions. So the certificate itself even doesn't limit it only to the water quality standards set forth in 401 and 404, but any state mandated condition in the NSP would fall into that.
Okay, we will take it under submission, try to issue a ruling on it sometime in the near future. Is there anything else that we need to talk about before we recess for the day? Are we finished here? Okay, well, we'll stay in recess.